The Supreme Court gives detainees their day in court. Jeffrey Brown begins our coverage.
Today's decision extends the Bush administration's losing streak to 3 Guantanamo-related cases. In 2004, the Supreme Court said U.S. federal courts had jurisdiction to decide whether detainees at Guantanamo were rightfully imprisoned. In 2006, the court invalidated an executive branch decision creating military tribunals, saying it lacked congressional authorization. In response, Congress passed the Military Commissions Act of 2006, which instituted the military tribunal system now in use at Guantanamo. Part of that act removed the habeas corpus protection for detainees, the ability to challenge their detention in court. And it was on this that the latest legal debate centered. Today's ruling involved 2 cases, Boumediene versus Bush and Al-Oda versus United States. Lakhdar Boumediene, an Algerian national, was arrested in Bosnia in October 2001. Bosnian authorities accused him of plotting to attack the U.S. embassy in Sarajevo, and he was handed over to the U.S. military. Fauzi Al-Oda, a Kuwaiti, was in Afghanistan in 2001 on what he claimed was a humanitarian mission. He crossed into Pakistan after the U.S. invasion. He was captured and transferred to U.S. authorities, who sent him to Guantanamo. 35 other detainees are included in these cases. In all, some 270 men are currently held at the detention center on the eastern end of Cuba. The facility was opened in early 2002 and instantly created worldwide controversy over the legal status under which prisoners remain held. Allegations of abusive interrogation practices have also been lodged. The military tribunals were in session just last week with the arraignment of top members of al-Qaeda, including Khalid Sheikh Mohammed, the self-proclaimed planner of the 9/11 attacks. And for more on today's decision, we turn now to NewsHour regular Marcia Coyle of the National Law Journal. Marcia, let's fill in the picture a bit. What exactly were the detainees asking the court for?
Okay, Jeff, at the heart of this case is the Constitution's writ of habeas corpus, a fundamental safeguard of liberty. When it's invoked, the government must come forward and justify why it's holding someone in detention. The Constitution itself says it may not be suspended except for public safety in cases of invasion or rebellion. The detainees in these 2 cases essentially asked the court 2 questions. First, do they have any rights to challenge the legality of their detentions through a writ of habeas corpus? And second, if the court said yes, they did the Military Commission Act of 2006, which stripped the federal courts of their authority to hear habeas petitions, act as an unconstitutional suspension of the great writ of habeas corpus?
You and I both were just saying our Latin. We took Latin a long time ago, but habeas corpus, let us have the body, or bring forward, produce the body, basically.
Exactly.
So an important legal, throughout legal history, legal tradition, Justice Kennedy said what?
On the first issue, Justice Kennedy held for the detainees. He made a lengthy analysis of the history of habeas corpus, which goes back centuries, and ultimately concluded that the Constitution has full effect in this area at Guantanamo Bay because of the framers' understanding of habeas corpus as a key element in the separation of powers, and also because of the status of Guantanamo Bay. As the court found 4 years ago, Guantanamo Bay, for all practical purposes, is under the control of the United States. The court today rejected the Bush administration argument that because Cuba owns Guantanamo Bay, it's outside the jurisdiction.
So not part of the United States, but the court is saying under the jurisdiction for all practical purposes.
That's
at least
correct.
In this place.
So these detainees did have the Constitution's protection of habeas corpus. On the second issue, as to whether the Military Commission Act of 2006 ran afoul of the Constitution's suspension clause, the court here again agreed with the detainees and not with the Bush administration that it did. in looking at this question, the court had to ask, has the government provided an adequate substitute for habeas corpus here? The government argued that another federal law, the Detainee Treatment Act, was an adequate substitute. That law set up procedures for review of detainees' status by combatant status review tribunals, and it also provides for very limited federal court review of those decisions. The Supreme Court, Justice Kennedy, in looking at this substitute, felt it fell far short of what habeas corpus provides.
But Chief Justice Roberts disagreed.
He
and
did.
Sided with the government and thought that that process was fair.
That was the core of his dissent. He felt that these procedures were more generous for aliens held by the United States than any other time in our history. And on that ground alone, he would have ruled for the government. Also in dissent was Justice Scalia. He wrote separately, and also Justices Thomas and Alito joined the dissent. Justice Scalia simply does not accept the premise that the Constitution's protections extend beyond the boundaries of the United States. And he also felt that this decision today would result, he said, in more Americans being killed. He noted that some detainees that have been released have returned to the battlefield.
Now, just in terms of what happens next legally, just as we sat down, there was a bullet on the newswire. U.S. military commission trials of Guantanamo detainees to proceed despite court ruling, says the Justice Department. Now, what does that mean, and what does it mean for the larger group of detainees?
Well, I think the decision will not have an immediate impact on these trials. These detainees have been charged with crimes. The court's decision first will have an immediate impact for the 37 detainees who went to the Supreme Court. The court made very clear that it felt these detainees, many of whom have been held for at least 6 years, are entitled to prompt review. For other detainees, he said, the executive branch is entitled to a reasonable period to determine their status before a federal court entertains a habeas petition.
But briefly, ultimately, a federal judge could let some of these detainees order them to be released.
That is one of the traditional remedies of habeas corpus, to release the person.
All right, Marcia Coyle, thanks a lot.
My pleasure.